Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Risa Arisewonia, and today I'm here to take you through customary tenancies. As per Section 1 of the Lands Act, 2020 Act 1036, customary tenancies is a lease of all interests in land in Ghana, based on the hierarchy that has been listed. Section 1 says that interests in land are allodial title, common law freehold, customary law freehold, usufructuary interest, leasehold interest, and customary tenancies. So today we'll delve into the topic of customary tenancies. So what then is a customary tenancy? Under Section 7 of the Lands Act, a customary tenancy is defined as A. An interest in land which is created by contract. B. Arises where a stew or skin or clan or family which holds the allodial title or a person who holds a customary law freehold or usufructuary interest enters into an agreement with another person to grant that other person an interest in land upon agreed terms and conditions. And C. It may involve the payment of rent, the sharing of the produce of the farm, or the physical partition or severance of the farm or land. The definition of customary tenancies under Section 7 is very broad, so I'm going to pinpoint the necessary parts of it which you must note so as to understand what exactly a customary tenancy is. The first point to note is that it's an interest in land, which is created by contract. Contract means that it's an agreement between the parties. So for a customary tenancy to be created, the people involved in it must have agreed to create it. It cannot be created when one person is not aware of it. And also, a customary tenancy can either be created by an allodial title holder or a person who holds a customary law freehold or a usufructuary interest. In my previous videos, I defined an allodial title holder to be the highest interest in land, which is either held by the stew or skin, clan, or family. So from this, you have to understand that a stew or skin can enter into an agreement with a person to create a customary tenancy. A usufructuary interest holder can also enter into an agreement with that person to create these customary tenancies. Customary tenancies must also have agreed terms and conditions, which means that there must be some arrangement between the parties, of which if one person flouts it or that person decides not to fulfill that particular term, it extinguishes or it destroys that customary tenancy. And it may involve the payment of rent. This particular line means that it is not always that a customary tenancy involves someone giving money. It can also be that the consideration attached is the sharing of the produce of the farm. So let's say you enter into an agreement with a chief to cultivate a cocoa farm. Maybe in that particular agreement, the two of you decided that you will not pay money monthly or yearly to the chief, but rather when the cocoa crops yield a harvest, you will give, say, maybe 3 bags of the cocoa to the chief. That 3 bags of it that you give to the chief is a consideration, and it forms part of the agreement you have with the chief. A customary tenancy can also be based on the physical partition of the farm, which means that you may have cultivated the farm for the particular person to be used by you. But as per your agreement, the consideration is not that, say, you will give money to the person you entered into the agreement with, or you give produce, but when the crops yield the harvest, you physically divide the farm so that everyone will harvest the portion that he or she wants. This basically is what customary tenancies is all about. In Ghana, customary tenancies are focused or they are found usually in Akan communities. And in the Akan communities, there are 2 types of customary tenancies which exist. These are the Ebusa tenancy and the Ebunu tenancy. So let me first explain what the Ebusa tenancy is. Ebusa tenancy is where, by the agreements between the parties, the grantor of the land, the grantor in this case will be the allodial title holder or the usufructuary interest or the customary or common law freehold interest. So where that grantor agrees with the grantee, who will be the tenant, that he is giving him an uncultivated land, which is a land that has not been touched, or some will say a virgin land. He's giving the uncultivated land to the tenant or the grantee to cultivate it and use it, and that in the event that the crops yield a harvest, the crops will be divided into 3 equal parts, of which a third of it will be given to the grantor. That is what the Ebusa tenancy is all about. So the key words for the Ebusa tenancy is that the land must be an uncultivated land, of which the grantee will use it in a manner he wants, and then a third of it, the third of the produce, not the farm itself, but the produce will be given to the grantor. Ebunu tenancies, on the other hand, is when the grantor grants an already cultivated land to the grantee, or he grants an uncultivated land, but he provides financial assistance to the grantee to cultivate the crops, of which, if it yields a harvest, it will be divided into 2, and the tenant will take half and the grantor will take half. So those are the differentiating factors between the two. For Ebunu tenancies, the land need not necessarily be uncultivated, but for the Ebusa, the land must be an uncultivated land. And also, for Ebunu, the produce is divided into 2, but Ebusa is divided into 3. The case of Kofi and Sesu explains what exactly an Ebusa tenancy under the Akan system is all about. So I encourage you to read that case to know what exactly the Ebusa tenancy is all about. Professor Kluge, in his article, The Family, Property and Succession Among the Northern Ewe Speaking People of Ghana, identified a different customary tenancy which exists among the Ewe people of Ghana. This tenancy is the Dibi Mami Dibi kind of tenancy. In this case, the grantor gives the land to the tenant, of which the tenant cultivates it. But when the crops yield a harvest, the land is physically divided so that the tenant and the landlord will each harvest their portion. So you'd realize that under Section 7 of the Land Act, all these tenancies are recognized under it, because the Dibi Mami Dibi will be the physical partition or severance of the farm or land, and the Ebusa and the Bunu will fall under the sharing of the produce of the farm. These are the main kinds of tenancies that we have in Ghana. Of course, when it comes to interest in land, you'd realize that there are certain rights that come with it. So for the tenant has a right to quiet enjoyment of the land. The tenant should be able to use the land to cultivate it in a manner that he wants, as per the agreement he had with his landlord. The case of Atta and Esson explains this carefully and explains it expediently. So I encourage you to read that case as well. Under customary law, however, the tenant does not have a right of alienation, because this interest in land does not come with the granting of your interest. You just allow or permit the person to use your land. It does not necessarily mean that you are giving the person ownership of your land. You are rather giving the person possessory rights over your land. So for customary tenancies, the tenant does not have the right to alienate the land. However, he has a right to dispose of the tenancy during his lifetime, but with the approval of the landlord, who may or may not exercise the right of preemption. The right of preemption is basically the right of first choice. So in the case the tenant wants to grant his possessory interest in the land to someone, he must first inform the landlord, of which the landlord must have the right to initially state that maybe, you know what, just give it to me, or don't give it to me, you can give it to this person. But the tenant must ensure that the landlord exercises his right of preemption. Another right of the customary tenancy is that it is heritable, in the sense that it may be passed on to the next of kin of the tenant in fulfillment of the necessary procedure prescribed by custom. However, where the parties agree that it shall not be passed, then that tenancy will not be passed. Of course, at this juncture, you should realize that there are certain instances that will cause this customary tenancy to come to an end. The first case is when the person abandons the land. If you enter into an agreement with a landlord that you are going to cultivate the land for maybe food or cash crops, and you eventually decide that you don't want to do it anymore, so you abandon the land, it ends the interest. That interest is no more, it doesn't exist no more. So that is a way in which a customary tenancy can come to an end. Another way in which it can come to an end is when there's a failure of a successor. Failure of a successor here means that the tenant may have children, and the tenant may have been using the land to, say, cultivate plantain or cassava. But when he passed on, his children failed to continue with the farming activities on the land. So when they fail to do so, the customary tenancy is extinguished. It can also come to an end when the farm is destroyed by natural causes. Let's say there's a fire outbreak on the farm or flooding which destroys the farm. The customary tenancy will come to an end. It will also come to an end when the tenant breaches a specific condition in the agreement. As I stated earlier, Section 7 of the Land Act states that a customary tenancy is characterized with agreed terms and conditions. So if there's a particular condition in your agreement of which if you decide to flout it or you breach it, the customary tenancy will come to an end. It is as simple as that. The moment you decide to breach that condition, the customary tenancy will be extinguished. However, as per Section 7 of the Land Act, 7C states that a customary tenancy may involve the payment of rent. The may here means that you may not always pay rent when it comes to customary tenancies. So the tenancy may be gratuitous, which in the lay term will say that it may be free. In land, when the customary tenancy is gratuitous, it is classified as a customary license. A customary license is basically, as I stated earlier, is a free thing. So it comes up when the tenancy is created, but it confers the right to occupy and use the land subject to agreed terms. It may be done either by the allodial title holder, a usufructuary interest holder, a customary freeholder, customary law freeholder, and a common law freehold. It may be created by the allodial title holder, the customary law freehold, and the usufructuary interest holder. So, for customary licenses, you do not pay the rent, and it may be granted either to a member of the family or stool or skin or clan, or to a stranger. The stranger here does not necessarily mean that the person is a foreigner. Maybe the interest was created in an Akan community, but it's an Ewe who has come for the land to cultivate it. So you can grant that interest to the Ewe. The Ewe is a Ghanaian, so you can do that. It could either be for a short term or for a long term. If it's short term, that means that it's seasonal. It is for a particular season, so it does not exist throughout. And for seasonal customary licenses, they can't be renewed when the season is coming to an end. It will rather be for long term when it is for an annual purpose. Let's say you are cultivating a cash crop like cocoa, then it may be annual. And in that case, you renew it when the agreement is coming to an end. In the case of Nya Asenshe and Efibiyesan, the court was of the view that a sowing license is not heritable from the tenant farmer to any of his next of kin, but the court concluded that if the sowing tenant, however, dies before his seasonal crops are gathered, his successor or next of kin is entitled to reap the produce from the land. So in this case, when it comes to seasonal licenses, it is not something that your next of kin can inherit. But as per the case, if you died before your agreement came to an end, your next of kin will be entitled to reap the produce from the land. So customary licenses in relation to seasonal licenses are not transferable or heritable by your next of kin. By way of recapping, I define a customary tenancy to be an interest in land which is created when an allodial title holder, a customary law freehold, or a usufructuary interest enters into a contract with a person on agreed terms and conditions for the person to occupy the land and to, produce something on it. But it may or may not be subject to the payment of rent, or for the consideration, it can be characterized by the sharing of the farm produce or the physical partition of the farm. I also highlighted the types of tenancies we have, which are the Ebusa and the Ebunu, which each of them have their specific characteristics. And I also made mention of the Ewe customary tenancy, which is the DB Mami DB. I also highlighted customary licenses, and I hope that in your studies, you'll be able to remember everything we've studied so far. Thank you for joining us again on a wonderful session today. I hope you do like, you comment, and you share our videos. Have a lovely day.